And that's another reason why it's so important, if you can, to have these things done ahead of time with someone you trust, rather than getting into a situation where you might find that the person doesn't have the patient's best interest in mind. Once I die, my medical power of attorney doesn't have any more authority except to request an autopsy or refuse an autopsy on my behalf, to make funeral arrangements or cremation arrangements for me, or to make decisions about organ or tissue donation. They can't take my medical power of attorney document to the bank and get my the money out of my checking account. They can't take the medical power of attorney document to a lawyer and say, you know, get my mom's medical records because I'm thinking about filing a lawsuit. That would have to be the executor or the administrator of my estate who would do that. The medical power of attorney doesn't have that authority once I'm deceased. And it's the same thing for a healthcare surrogate. They can make these decisions, these 3 categories of decisions after I'm deceased, but that's all. So we talked about selection of a healthcare surrogate. In addition to kind of going down the list that the legislature gives us, the other considerations that the physician in the hospital will make is, does this person know the wishes of the patient? Are they, or have they been in regular contact with that individual either before they came into the hospital or since they've been in the hospital? Have they demonstrated care and concern for the patient? Do they have the ability to visit the individual? That's not always possible. We have had patients who maybe have had some kind of a medical event or crisis when they've been traveling, and their family is in New York. So we're communicating with a healthcare surrogate in New York, even though the patient is here. It's not ideal, but sometimes that's the best that can be done. They also want someone, if possible, to be able to engage in face-to-face discussions with the medical team about the patient. And again, sometimes that's not possible just depending on location. The other sad fact that I think I didn't realize until I started working in-house in a hospital is just how alone some people are. There are people who literally have no one, and it's sometimes very, very difficult to find an individual who can even serve as a healthcare surrogate. And when we can't find someone, we call the HHR, and so a representative of the state who's never met this person before, has never had any contact with them, doesn't know anything about their background, doesn't know anything about their religion, doesn't know anything about their anything, ends up making decisions for them. And again, that's just a very sad fact of life that I think a lot of people don't realize, about healthcare, is that sometimes you find people who really just have no one, and so we rely on the state then. If we select a surrogate, so let's say we go down our list and we find that a granddaughter is the best person to make decisions for the patient that we have in the hospital. And let's say after the granddaughter has been making decisions for a couple of weeks, the patient's sister shows up and she says, I don't think you should have picked that granddaughter, and I'm higher on the list of priority by the statute, and you should listen to me. That is not our problem. At that point, if the sister wants to challenge it, she goes to court, she challenges it, she gets the judge to tell us to change our mind. But until that happens, we're gonna keep dealing with the granddaughter, because that's the information and that's the best decision we were able to make at the time. And as long as the granddaughter is participating and helping us make the decisions that need to be made for that patient, we're gonna stick with her. Let's say that a patient comes to Ruby we've gone through this whole process, we've made the determination that the patient no longer has decision-making capacity. We didn't find a medical power of attorney for that patient, so we selected a surrogate. And now it's time for the patient to go to Encompass to get some rehab. Encompass doesn't have to start that process all over again. They can rely on what decisions we have made in our hospital about having incapacity and who the healthcare surrogate would be. Now, if the patient shows a great deal of improvement while they're at Encompass and they get their decision-making capacity back, then Encompass would make that determination and document it, and the healthcare surrogate would then step back once the patient's able to make their own decisions. But each individual institution doesn't have to go through the process over and over again, because that would be difficult for them, and it would also disrupt the care if we're changing every time a patient has to move from one place to another. DNR orders. Everybody is presumed to consent to resuscitation unless there is a DNR order. So a DNR order is something that a patient or a healthcare surrogate or a medical power of attorney discusses with a physician. You can put it into your living will, you can discuss it with your medical power of attorney, and typically what would be done in that situation is if I'm in a persistent vegetative state or if I have a terminal condition, I don't want CPR, or I don't want, I don't want whatever. If I haven't made that determination, and a doctor approaches my medical power of attorney and says, do you want to make your mom DNR? Then it becomes the medical power of attorney's decision if I haven't already written it into my living will. And then we'll talk about post forms in a minute. That's another way that a DNR order can be entered. One thing to think about, and I think a lot of people don't understand this, people will say sometimes in their living will, I don't want to be intubated. I don't want the tube down my throat that breathes for me. But they'll say, I do want CPR. We can't really have one without the other, because the P in CPR is pulmonary, and if somebody's going to do chest compressions to get my heart started, they're also going to intubate me to make sure that I'm getting oxygen flow. So you can be more specific and say, I would accept chest compressions, but I don't want intubation, and that would be a better thing than to say, I don't want intubation, but I do want CPR, because those two things don't really match with each other. A DNR can be written by a physician, an advanced nurse practitioner, or a physician assistant. It can be done upon patient request. A patient can get to the point in their medical care where they would say, I don't want to be resuscitated if something happens. If there is no medical power of attorney or healthcare surrogate to discuss the issue with, a physician can enter a DNR order with a second opinion from another physician. And this happens not infrequently, but it happens when really they've done everything and there's no more treatment options available except just keeping a person alive artificially, and so they can enter a DNR order at that point. If a parent has a minor child who has some sort of medical condition and they would not want the child resuscitated, the parent can make that request, but again, it would require the opinion, a second opinion from another physician that that's an appropriate decision to make given the child's medical condition. If it's a child between the age of 16 and 18, they participate in a DNR decision. And if there's a conflict between what the parent wants and what that 16 to 18-year-old wants, then you honor the decision of the child, the 16 to 18-year-old. If there's a trauma, if somebody's on 79 and there's a car accident, a DNR order, even if there is one, and even if the EMS people had some way of knowing about it, they're not going to honor the DNR in that kind of emergency trauma situation. Anytime there is a trauma, CPR is always going to be an option on the table for the emergency personnel. And you can imagine it would be very difficult for them to appear on a trauma and then kind of have to spend any amount of time researching whether there's a DNR or not. So they're always going to default to doing CPR in a trauma situation. Post forms. So this is a physician order for scope of treatment. It's a standardized form, and this is really a form that people are meant to keep in their homes or in the place where they are most often, so that if EMS or someone shows up, it's clear what kind of treatment the patient does and does not want. So let's say, for example, I am at home and I'm on hospice because I've decided I don't want to have any more treatment for my cancer. But one of the things that I have from time to time is trouble breathing. And when that happens, my family calls 911, somebody comes to the house, and they're going to give me oxygen and help me breathe. But this post form might say, do not resuscitate. So if you come and my breathing problem has progressed and I'm actually unconscious, I don't want CPR. It might also say things like, I don't want antibiotics, or I don't want this particular kind of medication, or I want to go to UHC, I don't want to go to Charleston. It can lay out for you the medical treatment that you do and don't want. The recommendation is that you post that on your refrigerator, and that way if a medical provider comes to your house, they see it, it's bright orange, all the forms are bright orange. They know that that's a post form, they know that they can refer to it, and they kind of know the limitations of the treatment that they're going to be able to provide to you, you know, based on your wishes and what your doctor has predetermined is going to be appropriate for you. And they can follow that because it is an actual order from a physician. And that's why it's called post, physician orders for scope of treatment. So mature minors, we've talked about this a little bit. And the way this came about was, there was a medical malpractice case arising out of Charleston. A patient had a chronic illness. I think it was cystic fibrosis. I'm not 100% sure about that now, but I think that's what it was. And this child had been through treatment over and over and over and over again. And the medical condition was just getting worse. And the child, who was 16 at the time, had a discussion with his physician to say, I've been through this before, I've been intubated before, I hate being intubated, I know that my time is almost up. If I have another crisis, I really don't want to be intubated, I just want to pass. So the parents come along, there's a crisis, and they know about this discussion that the child has had. And they say, don't intubate the child, and the child passes away. A few months later, the parents sue the physician for not doing the intubation. And they say, you should have consulted with the child, and you should have gotten their written consent to not be intubated. And believe it or not, that case went to trial, and the doctor lost that case. But because the doctor lost that case, the legislature stepped in and said, no, this is not right. If a child really can make a decision, if they're deemed by their doctor to be mature, to understand what's going on, what the implications of their decision are, then they should be allowed to participate in the decision. They may not get to make the decision 100% on their own. Their parents still have input, but if there's a conflict, you would most likely go with the decision of the child, and that kind of insulates and protects the doctor in that situation, so we don't have the situation like the lawsuit that was brought in Charleston. It's not exactly the same as an emancipated minor. If you have gone to court and been declared emancipated, or if you're at least 16 and married, you are, for all purposes, considered an adult. So you can sign your own consent forms, you can request or decline medical care. A mature minor, again, still kind of is a co-decision maker with their parents, but if there's a conflict, then you go with what the mature minor wants.
It's kind of scary. I know 20-year-olds who can't make decisions. That's kind of scary.
Understood. And let me tell you what's even scarier. Like, we have had this situation before. A 14-year-old girl has a baby. If that 14-year-old girl a month later needs her appendix taken out, we have to go to her mother or dad to get permission to do her appendectomy. But if her baby needs surgery, we're supposed to go to her, the 14-year-old. Yeah, so it's a fluke in the law, and it puts us in a great deal of angst to be in that situation. Typically what happens when we're lucky is grandma is also helping take care of baby, and so grandma can weigh in, and that gives us a little bit more comfort that a mature decision maker is at least involved. But yeah, it's very much a fluke of the law, the way that decision making can occur when you have a minor who has a baby, and decisions have to be made. Again, whether someone is a mature minor is a medical decision. The physicians have to make that decision. They have to document the reason for their decision, the date on which they made the decision, and if there are any limitations to their decision. That's the presentation as far as the slides go. But what I have here are various documents, and I brought copies of them, but if there are not enough copies of them, you can go to this website, wvendoflife.org. And it is a website that was actually started by a professor at the School of Medicine in Morgantown. And he keeps all of these forms up to date and in the form that they're supposed to be based on the most current law. You can print them off, you can fill them out yourselves. You don't need to go to an attorney for any of these forms. You always can if you want to, but these are meant to be available and accessible to members of the public so that you can just pull them off, print them off, and fill them out yourselves. Each one of these forms is accompanied by a list of common questions, and then the answers to those questions, and instructions about how to fill them out. And they're written in pretty plain language, not like a lot of here to's and wherefores and all that kind of stuff that lawyers like to throw in so that you think they're really important. It's written in good plain English so people can understand it. But what we have here is we have the living will. So that's what you would fill out to tell your family or whomever, these are the things that I do and don't want. We have the medical power of attorney. This is who I want making decisions for me. And then, very conveniently, they have a combined form. It's a living will and a medical power of attorney. So it's one document that you fill out that has both what I want and who I want to make decisions for me. There's also one specific for mental health advance directive. So if you happen to have a family member who has a chronic mental health problem and they have these periods of time when they are able to make decisions for themselves or they aren't able to make decisions for themselves, this is a very good thing to fill out. It allows the patient to say, these are the kinds of treatments I would prefer, these are the kinds of treatments I would not prefer, these are the places where I would prefer to get treatment, these are the places where I would prefer not to get treatment. It even goes so far to say as, when I am having a mental health crisis and I'm not able to take care of myself, I give temporary custody of my children to this person, or I give temporary custody of my pets to this person. And so all of that is laid out in advance. So when that person is in a crisis, people aren't scrambling and the healthcare providers aren't contacting DHA to try to find out what to do with their children and things like that. The other thing that mental health advance directive does is the patient, kind of knowing what their mental health condition is, can say, when I'm in a crisis, this document is revocable or it is not revocable. So there are people who, you know, when they're not in the midst of a mental health crisis, understand, once my symptoms really flare up, I'm not going to be in a position to make good decisions. So I don't want to be able to revoke anything I've said in this document while I'm in that crisis. And then there are other people who would say, you know, I still want to be able to be involved in some of my decisions if I can, and they can make that determination. Again, all 50 states have something similar to this, and whether it's the medical power of attorney, the living will, or the mental health advance directives, again, just because it's not exactly in the form that West Virginia uses, it will still be honored and recognized if you bring it from another state. So what questions do people have? Yes?
Do you have to have the original forms, or can you put these on file somewhere?
Yeah, so a couple of different ways you can put them on file. You can actually register them at this West Virginia endoflife.org. Now, I don't know that every hospital or every physician's office knows to go there and look for it, but that's one thing you can do. You can take copies to the hospital where you're most likely to get treatment.
Copies, you don't have to have original signatures.
You don't have to have originals. They can put it on file.
Then you upload it to your My Chart at WVU.
Yes, exactly. You can see it on My Chart at WVU. You want to give one to whoever you've designated to be your medical power of attorney, because if they show up on the scene, that's the first question they're gonna have is, okay, you say you're the medical power of attorney, how do I know that that's true? So they should have a copy. You should also, and we've seen this happen, if I make you my medical power of attorney, I need to tell you I've made you my medical power of attorney. Sometimes we'll see a document, it'll be a living will or a medical power of attorney in a patient's chart, and it's like, oh, well, this person is medical power of attorney, and we call you and you're like, I didn't know. Like, Dad didn't tell me he made me my medical power of attorney. Same thing with my living will. If I have certain directives in my living will, things that I do and don't want, and I've made you my medical power of attorney, I want to discuss that with you. You might want to flesh out with some questions. You know, well, what about this? What do you mean by that? You know, and just get clear about what I'm really saying as far as my directives go. And again, if you change your medical power of attorney or living will, you want to go back to all those places that you've put it on file and say, this is my new one. We will always go by the last date. So if I have one from 2012 and I've got one from 2022, I'm always going to look at the 2022 one. So, yes?
Is there a standard where a directive is no longer, like, it can be established that it's not being followed by the physician? Because you've identified an issue where you're coming in being resuscitated already. The doctor, I'm assuming someone has to physically read this material to be able to understand it. In that time period, I mean, like, I imagine there'd be a claim that you're not following my directives, and like, at what point does it, like, the actual physician have to stop?
Yeah, so, the law is written so that if the hospital or physician knows about the advance directive, they have to follow it. But like you said, if somebody comes into the emergency department and we don't know about it yet, then you're gonna get the full court press. And then after you've been in the hospital a couple of days, then we're like, oh, this person had a living will, oh, this is this person's medical power of attorney. That's when they would have to go back and, like, from that point forward, you know, honor what the wishes are and take the direction from the medical power of attorney.
If everybody had put their email down too, we will be glad to share her PowerPoint, cause I know it was hard to see the way the lighting was, but.
I was gonna ask that. You're way ahead of us, you're so smart. Look at you, so
For
smart.
endoflife.org,
Yes.
do you need witnesses or a notary to make that a legal document?
Well, the documents themselves do require,
Yeah, I did.
witnesses and notary. So as long as you filled out the document and those signatures are on there, then you upload it to the West Virginia endoflife.org and it's
Okay.
valid, yeah. Anything else? All right, thank you for inviting me.
Thank you, Christine. A couple of reminders coming up. We have our after hours, June the 20th, West Virginia Day. That'll be at Baton Hollow Winery. Leadership at Harrison applications will be out within the next couple of weeks. Those are due at the end of July. Also due at the end of July are our Tank Entrepreneur Pitch Contest applications. We have a couple of those over here. Those are also available online. Our next Business at Breakfast will be here on August the 11th. We'll take July off for vacation and holidays. And if you saw the media yesterday on the Boscov's Charity Day coming up October the 5th, if you'd like a pass, their $5 donation to the chamber. I have some passes with me today, so if you want one of those, just let me know. I'll also have them at the after hours and our upcoming events until they're sold out.
And you can't shop without them that day.
Yeah,
of the
on
pass. You
October
can't get
5th
in.
is the first day that they're gonna and only people with passes can shop that day. They will open on Saturday the 7th to the public. So, and they also get a free gift for going and 25%, I think it's 25% off their sale prices, so bargain. So, thank you all for being here. Happy Friday. We'll see you next time.
So exclusive.